Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
Later this month, the former England and Sunderland footballer Adam Johnson will be sentenced for 2 offences of sexual activity with a child and 1 offence of meeting a child following sexual grooming. All the charges involve a girl of 15. Johnson had denied the more serious charge of sexual activity, but was convicted by a jury last week. He's been told to expect a prison sentence later this month. But how will the judge decide the length of Johnson's sentence? Eleanor Laws QC is one of the leading barristers in this area of the law. She told me there were 2 options.
The judge can either deal with the sexual activity offences and sentence for those offences in a way that incorporates the grooming element, the background. And what he can do is increase the sentence. It can be aggravated by the background, and then approach the grooming offence, pass a sentence that means the 2 sentences run together. Or the judge can decide to deal with the 2 different types of offences separately. So look at the sexual activity offences, but then pass a separate sentence for grooming, which should run after the sexual activity with the child sentence is complete. So it follows on. Whichever way a judge decides to approach the sentencing exercise, the judge must take into account the totality of the sentence overall.
And what are we talking about as a total sentence then?
Well, it's very difficult to say, but the guidelines are clear, and the judge announced the guidelines that for the sexual activity offence with the child, the more serious one, the range is 4 to 10 years custody with a starting point of 5 years. Judges shouldn't really deviate from the guidelines without very good reason.
In those guidelines, there are a list of factors which have brought this case into the more serious category. Could you go through those and tell me what factors are likely to have some bearing on this case?
Well, the judge will look at the degree of planning involved in this offence, and it looks as if there was a degree of planning. The grooming itself, which was the background, took place over a period of time. Another factor is abuse of trust. There is the element here that you have a very well-known football player and the complainant was an avid fan, and he knew that. The disparity in age is another matter, although it has to be said that the complainant was 15, the defendant was significantly older, but that is something the judge can take into account. That is something that the judge has to look at very carefully.
In mitigation, Adam Johnson's counsel will tell the judge that the victim, although a child in the eyes of the law, was only 1 year away from the age of consent. How will the judge take account of that?
Well, public opinion has changed, hasn't it? Because if this offence had been committed a number of years ago, then no doubt a number of people would have felt that it wasn't quite as serious as we all do now. The reality is it is an offence, and the judge has to comply with the guidelines. And whilst there is some discretion when looking at the disparity in age between the victim and the defendant, to take that into account, and clearly if the offence had been committed upon a very young child, the judge has to take that into account as well. But it is still a feature, it is an offence, and the judge still has to sentence according to the guidelines.
Adam Johnson's football club, Sunderland, has come in for some criticism over the way it handled this case. What should a large employer do if somebody on their staff is charged with a sexual offence?
Well, I think the key question here is whether the club actually knew that Adam Johnson had accepted any offence or committing any offence at all. The evidence at the trial suggested that they did. And if that is correct, well, then the very least that they do, if they don't suspend him straight away, is to check their child protection measures and the systems that they have in place.
But it's not for an employer to try to prejudge the case. Whatever evidence it might have been shown by the police, whatever the defendant may say to the employer, We will go to enormous lengths to avoid prejudicing a trial by saying anything about a defendant. And if his employer suspends him, it's sending a message to the jury, we think this man may be guilty.
Well, it may well do. And the reality is, if the club did not know that the defendant, Adam Johnson, was admitting to any offence or was going to admit an offence, then you are innocent until proven guilty. The question is, did they know? And if they did know that he had either committed an offence or was going to plead guilty, then at the very least they should review his position and their child protection measures.
Eleanor Laws QC. Sunderland Football Club said it had lifted Johnson's initial suspension only after carrying out a safeguarding assessment. The player was sacked last month as soon as he'd admitted some of the charges he faced.